You cannot acquire a benefit or a burden of a court case or a court judgment of which you were not a party.
But what
that
happens? You haven't quite answered my question as to what happens in the time in which you were denied your right or your role as the chairman of that party. What about the decisions that were taken by a caretaker chairman, for instance?
I want to throw the question back at you. When a governor stays 2 years in office and it is later decided that that governor was wrongly declared winner, what would you say about the 2 years? That the rights and burdens that have accrued, would you say that they should be reverted?
That's on the one hand, but we do know that when that governor goes, all his commissioners as well, they go.
Of course.
The new governor has the right to bring in
and that is what has happened. All other members of the state ESCO that do not belong to the Ogegbego state ESCO will go. You have answered the question.
That has nothing to do with the candidate.
It doesn't have anything to do with the candidate, especially in the light of the fact that the fact of candidature lies with the national executive body, which is the representative, what you may call the alter ego of the political party, being a legal person.
We also heard the aggrieved senator, the aggrieved candidates before their names were substituted, speaking about their names being substituted.
Yes.
So one wonders, what legal provision or what law do you think they would have relied on to substitute their names?
You see, anything that is void ab initio is void ab initio. And I think Silas Ono addressed it. You cannot give what you don't have. If you have received something that is faulty from the beginning, there's no way you can work on with that thing if you realize that that thing is faulty from the beginning. But you need to just get to the one that is proper. That is what INEC did. When INEC realized its mistake, I guess that it realized its mistake, what it did was to collect the list from the proper party. So in other words, the list that it had collected earlier on was like a no list. It was like a no list because you cannot put something on nothing and expect it to stand. You don't give what you don't have. The source of that list cannot be the source that should give the list.
Because they think that it was a wrong decision to have substituted their names in the first instance because
substitution presupposes validity. For you to talk about substitution, then you must have been your name must have been validly before INEC. But if your name is not validly before INEC, then you cannot speak of substitution. So the word substitution shouldn't apply here, technically speaking.
So if the party had not gotten their names to INEC, they cannot claim that their names were substituted. That's what you're saying.
No, what I am saying is that if your name has been what analogy do I use now? Okay, let me just go straight to the point. When you submit a name that you ought not to submit, in the eyes of the law, that name does not exist. The second part to it is that you submitted the name that you ought to have submitted, the proper name that you ought to have submitted. In the eyes of the law, that second name exists. So the fact of substitution will come in for this second arm, not the first arm where the name that you submitted ought not to have submitted in the first place.
Okay, look at the arguments. They say in December 2014, when the Federal High Court ruled that Ejike Ogbebego's led executive was the only constitutionally recognized leadership of the party in Anambra to conduct the PDP primaries. They say that in spite of that, there was a parallel state executive of the PDP that went ahead and conducted parallel primaries.
When that PDP parallel ESCO conducted the primaries, they were acting as agents.
Okay, look at this other part.
Of the national body. They were not acting for themselves.
The other part, they now said, the National Electoral Commission, that's INEC, and the PDP's National Working Committee supervised the primaries conducted by Ogbebego's executive on December 6 and 7, 2014. And at the end of that exercise, the NWC of the PDP and the INEC declared Chris Upa winner for Anambra South, Prince John Emeka for Anambra North, and Anio Okonkwo for Anambra Central. And they just won.
You see, this is going into the details and facts. What we are discussing here has nothing to do with some of these little details. If you look at the macro explanation is that it lies with the party to present its candidate. It lies with the party. If the party discovers that the processes it has been following previously were not correct, it has a right as a legal entity to retrace it. And again, I also want to say that this issue of who should present candidates or which candidates are the appropriate candidates to have been presented, it's still before the Court of Appeal. That is what the Supreme Court has decided. That case is still pending. They ought to go back to that Court of Appeal and argue this case.
But you see,
the case is still alive.
we understand that part where
Yes.
you say it is the party that has to do all of those. But here, the part that they add that raises question is that they say the parties NWC and INEC.
I've said it. When you are working on a wrong route, and you
So
discover
INEC
that
too was working on the wrong route.
INEC came upon the invitation of the party as a legal person. So the party on its own can say, this is not the path we want you to walk through.
Okay. Can this be interpreted as saying, if they are saying the NWC and INEC, can it then be said that INEC actually received the list?
Which list?
The candidates?
The Ogbego's list.
Yeah. Can it be interpreted as such?
That is what I'm saying. You cannot receive something that the person that is giving it to you does not have the right to give to you. So that's why the principle of substitution must be looked at technically. You can only substitute what is validly before you. You cannot substitute what is invalidly before you. Something that is not validly before you. It is not a substitution. You are only correcting. That must be very, very, very clear. And again, this issue of I should be the candidate or I should not be the candidate is still a living issue. The Supreme Court has referred them to the Court of Appeal. The case is still pending at the Court of Appeal. So all the Supreme Court did is to declare that the sanctity of the order of the justice at the Federal High Court, Port Harcourt, must be respected and should be respected and still stands.
In other words, given the pendency of that suit, what did they do? Maintain status quo?
Given the pendency of course, given the fact that it's still the Court of Appeal, the matter is before the Court of Appeal,
Yeah.
It is just natural that they should go back to the Court of Appeal and raise further issues with regards to the candidature. Perhaps the Court of Appeal may decide in their favor. And maybe when they now get to the Supreme Court again, the Supreme Court will now come back and say, yes, even though this has happened all this while, these are the appropriate people to have been named as candidates. But for now, the Supreme Court was very clear that what is before it has nothing whatsoever to do with who has the power to nominate candidates or whether a candidate was appropriately or properly nominated or not.
Even at that, do you think INEC had to have accepted the list from
Ogbego's in the first instance?
In the first instance.
Well, yeah, I think it may have erred if you put it in proper perspective. INEC, perhaps, after realizing that it had erred, now retracted, now reversed itself, and went for the proper source of a list. I have not said here that Ogbego's candidates may not end up being the proper candidates. But for now, there was no such thing before the Supreme Court. So the appropriate people who should still be at the seat are those senators who have already been sworn in, and who PDP, as a corporate entity, as a legal person, says that we have sponsored as our candidates. You have always to refer to the party, to the person who is your candidate. It is a constitutional issue. It has nothing to do with the Electoral Act. It is something that borders on the peak and apex law of our land.
Unless if the parties are so aggrieved, they can then approach the court and say, listen, we have not followed our own rules.
That is it. And that case is still before the Federal High Court, the Court of Appeal. If you say that the rules that PDP ought to have followed, perhaps, for example, you say PDP should be stopped from going back on the conduct of the primaries they did with Ogbego. If you can say, okay, the Court of Appeal should have stopped them from going back upon their representation. In that case, you go to the Court of Appeal and argue it. And whatever the Court of Appeal comes up with should be implemented, should be enforced. But for now, there is nothing to talk about that affects the seats of the senators, the incumbent senators.
That's from this judgment?
From this judgment.
But
Nothing
you
whatsoever.
still think that there's a lacuna that can be exploited?
Well, in terms of lacuna, as a lawyer,
Yeah.
it's only through lacunas that we survive. Yes. It is only through loopholes that you win cases most times. You look at the loophole in cases. And so, yes, there will always be a loophole if you look closely. And that loophole can be exploited, especially at the Court of Appeal, because it's a pending case. It's still subsisting. The case is still living. The fact of who is the rightful status quo, or in point of fact, this case of who whose candidates should be at the Senate or at the House of Representatives.
Because some people say that there is no way the national body of the party can come and conduct elections in the state without the state ESCO being a part of it. And which state ESCO did
No, they are not. National body is not bound to
work with the state ESCO?
Yes, to work with the state ESCO, strictly speaking. In other words, they would ensure that the primaries are conducted in accordance with Section 87 of the Electoral Act. If that is done, whether the state ESCO participates or not, in law, it's irrelevant because it is the party itself as a corporate entity that is taking the decision.
But, but the people who participate in the primaries are usually gotten from the wards and congresses in the wards that take place there.
It is a simple thing. The primaries are simple issues. All this national body does is to call a group of people, most likely. And I'm not saying that the state ESCO shouldn't be involved. I am saying that there is nothing binding them if they don't involve the state ESCO. They most likely use the state ESCO, use the structure on ground to do what it should do in terms of conducting of primaries for National Assembly.
All right, so whether they can conduct those primaries without relying on the delegates at the local government and ward level is a different kettle of fish. And if this is a lacuna, you know who to speak to. Thank you for coming here this morning.
Thank you. I'm most obliged.
All right, Ikechukwu Kechi, legal practitioner, shedding some light on all of this. Well, we have to wrap it up at this point. Okay, we'll take a break.
Okay, no break? No?
No break? Okay, then. So there you go. That's it today, then. Thank you for watching. I'm Chamberlain Uso.
Well, thank you so much. I'm Maupe Ogun.
Many thanks. I'm Sulaiman Alede.